Let's continue with application and interpretation of tax treaties. Till now you might have learned that we are just discussing general terms of this chapter, and because of general discussion this chapter is not that much important from the examination perspective, but some of the phrases that we must understand not only for examination but also for our knowledge purpose. So let us have understanding of few more rules of interpretation which are internationally adopted while interpreting the tax treaties. Now whatever we are going to learn in this lecture are the principles enunciated in Vienna Convention of Law Treaties, because all the international tax laws or DTAA agreements are greatly influenced by this particular document. You can say this is a framework for interpreting the tax treaty that is signed by the multi countries. So there are various articles. Article number 26 say pacta sunt servanda. So this is like Latin phrases that they have used. In literal translation to English, it says in a good faith. Obviously, when we have signed the treaty with the foreign country, the treaty has to be signed in a good faith and it has to be implemented in a good faith. So every treaty in force binding upon the party then must be followed by them in a good faith. The parties to the treaty should not dishonor their international commitments with each other by retrospectively amending their domestic tax law or by not abiding by the treaty terms. So obviously when you have signed the treaty, you have not signed the treaty. It's not like a politician's commitment that they say one thing and then they do one other thing. Because it is a written commitment with a foreign government, you should not play the hide and seek game with them. You should actually give the effect to the double taxation avoidance agreement, though it may result in losing some of the tax revenue of your country, but because you have signed the treaty, you have to give the full benefit. Article 28, non-retroactivity of treaty. See, treaty should not have retrospective effect unless and until expressly provided. Obviously, by default, all the provisions or all the benefits which are written in the treaty will have only a prospective application and not the retrospective application. Okay. Unless a different intention appears from the treaty or is otherwise established, otherwise it is clearly written. Treaty provisions do not bind a party in relation to any act or fact which took place or any situation which ceased to exist before the date of entry into force of the treaty with respect to that party. Meaning thereby all the matters which are already closed or which has happened in the past will not get any treaty benefit. Only matters which are going to happen from now onwards will be covered. In other words, unless otherwise provided, treaty cannot have retrospective application. Territorial scope. So we have signed the treaty with United Kingdom. It will be applicable to whole of India or any part of India, whole of India excluding Jammu and Kashmir. So what is the understanding that we should derive? So by default the treaty, once you have signed the treaty, it will be by default applicable to whole of India. If any exclusion is needed, they will provide in the treaty. Unless a different intention appears from the treaty or is otherwise established, a treaty is binding upon each party in respect of entire territory. Please understand, by default it is applicable on whole territory. General rule of interpretation, and this was we were discussing till now. So we have to interpret treaty in case of confusion, and by default rule of interpretation is literal interpretation. Give the word exactly same meaning grammatically which is derived and which is understood by both the parties. So a treaty shall be interpreted in a good faith in accordance with the ordinary meaning to be given to the terms thereof in a context and in the light of the object and the purpose. This is the basic principle. It states that treaty should be interpreted first giving the ordinary meaning to the language. It is only if the ordinary meaning is ambiguous or it leads to illogical results that the purpose of the treaty may be considered. So by default, primary rule of interpretation is a literal interpretation. Other rules of interpretation will come into play only when the primary rule of interpretation or literal interpretation is giving you absurd results. The context for the purpose of interpretation of treaty shall comprise, in addition to the text, including the preamble and annexes. So we will refer the whole law, preamble and annexes. Any agreement relating to treaty which was made between all the parties in connection with the conclusion of the treaty, this also you will refer. Any instrument which was made by one or more parties in connection with the conclusion of the treaty. Sometime what happens, you have signed one agreement with India, UK, India, Australia, we have different agreement, and then in G20 summit all these countries have come together and they have signed a mutual agreement. Okay, So we have to follow the country-wise agreement as well. At the same time, we should also look into the additional document or agreement which is signed after signing the original agreement. The following shall be taken into account together with the context in that any subsequent agreement between the parties regarding the interpretation of the treaty or application of its provision, any subsequent practice, see here it is agreement and here it is practice in the application of the treaty which establishes the agreement of the parties regarding the interpretation, any relevant rule of interpretation of law applicable to relation between the parties. A special meaning shall be given to the term if it is established by the parties so intended. Sometimes what happens, like in India, any act will have section 2 as the definition. Whenever they have a definition clause for a particular word, obviously the intention of the party was to give the specific meaning, like the meaning of the word relative. The relative can be considered differently in different countries and different laws, and therefore we have to define what is relative according to this particular treaty which is signed by the two nations. And therefore whenever law specify or whenever treaty specify meaning to particular term, we have to follow that particular meaning. Article 32, supplementary means of interpretation. So golden rule of interpretation is literal interpretation. Apart from that, you can definitely follow the supplementary or additional rule of interpretation when Article 31 doesn't operate. Okay. Recourses may be had to be supplementary means of interpretation, including the preparatory work. Preparatory work means what was the work which was done before, or the background work done before signing the agreement, the preparatory work of the treaty, circumstances of its conclusion, in what circumstances the treaty was signed, in order to confirm the meaning resulting from the application of Article 31, that is literal interpretation, or to determine the meaning when interpretation according to Article 31 leaves the meaning ambiguous or obscure, that means you are not able to determine the logical meaning, leads to result which is manifestly absurd or unreasonable. Article 33, interpretation of treaties authenticated in 2 or more languages. Sometimes India and Japan may sign treaty in English as well as in Hindi or in some other languages, and whenever you know that exact translation to any language is not possible, therefore there will be a common language. Apart from common language, there might be the regional language treaties. So whenever treaty is signed in any language or more than any other, it's not in a common language or more than two or more language, then what type of authentication is required? So obviously the translated law will also, or the translated treaty will also need to be signed by the parties, and we will understand that original treaty should be valid even in translated treaty. So meaning should not change to the great extent. Whenever meaning is changed, both the parties will sit together and they will give the appropriate meaning, and then they will agree upon that particular meaning. When treaty has been authenticated in 2 or more language, the text is equally authenticative in each language. You cannot say this is more powerful and that is less powerful. Both are almost equal, unless the treaty provide the parties agreed that in case of divergence, the particular text shall prevail. So whenever there is a different meaning, both the parties will sit together and they will conclude what meaning exactly they wanted to assign. A version of the treaty in a language other than one of those in which the text was authenticated shall be considered as the authentic text only if the treaty so provides or the parties so agree. So other text, unless and until it is authenticated, we will not agree to that text. We will follow the original document which is signed by the two countries. The terms of the treaty are presumed to have the same meaning in each authenticated text because both the language are different, except where particular text prevails in accordance with the para 1. Obviously, whenever you have given a different meaning according to mutually agreed principles, then we will give the different meaning. Otherwise, we will follow the same meaning in both the treaties, though they are into different languages. General rule regarding the third state. Now, India is signing treaty with Sri Lanka. Okay, will it applicable to Dubai? Obviously, no. Will it not applicable to Dubai? Obviously, no. If we have to make it applicable to Dubai, this third country will authenticate that particular clause. Okay, this clause is also applicable on our nation. Okay, a treaty does not create any obligation or right for the third state without its consent. Obviously, if they give the consent and if they want to take the benefit, we can share the benefit. Article 42, validity and continuance of the force of the treaty. Now, don't read the whole thing in detail. Obviously, the validity because we are signing the agreement, whether it is time-bound agreement, so whether it is applicable for 5 years or 10 years or infinity or without any modification. So that is the validity of the agreement. The validity of the treaty or consent of the state to be bound by the treaty may be impinged only through the application of the convention. So obviously we will come into the convention and then we will discuss there what type of applicability should be assigned to the treaty. The termination of the treaty or denunciation or withdrawal of the party. So some party may not like to follow the treaty, or they may declare the in government a lot of changes happens. Like India had signed so many treaties in the time when the Congress was ruling the country, and now BJP is ruling the country. So because there is a huge shift in the political status of the country, there might be the intention of the India or government of India to not follow or declare certain treaties void. This might happen, but that has to be done through appropriate procedure. A termination of treaty or denunciation or withdrawal of the party may take place only as a result of application of the provisions of the treaty or the convention. So in convention there will be a standard procedure, or there will be an exit clause in the treaty. According to that it should happen. Appropriate procedure has to be followed. The same rule applies to the suspension or operation of the treaty. So withdrawal or termination or denunciation means permanent cancellation. Suspension means for this particular period we will not apply the treaty. Termination or suspension of the operation of the treaty in the consequence of the breach. Whenever you don't follow the treaty, you don't follow the norms, obviously the other party should have right to terminate the treaty. A material breach in a bilateral treaty by one of the party entitles the other to invoke the breach as a ground for terminating the treaty or suspending its operation in whole or any part. Material breach of multilateral treaty. One is bilateral treaty. Bilateral treaty means one country to another country, and multilateral treaty means when 20 countries, 40 countries, they come together in a convention and they sign a multilateral treaty. One treaty signed by all the 40 countries. The other parties by unanimous agreement to suspend the operation of the treaty, whole or in part to terminate it in the relation among themselves or defaulting the state. So either they can withdraw the treaty with all the 40 states, or they can withdraw the treaty with only particular defaulting state. That is the choice given to the other party. A party specifically affected by the breach to invoke it as a ground for suspending the operation of the treaty in whole or any part of relation between itself and the defaulting state. Obviously this option is there. Any party other than the defaulting state. Any party other than defaulting state. Obviously defaulting state has made a default and cannot go there and declare, oh, we don't want to follow the treaty. You are a defaulter, you should not say this. Other parties should say that. Okay, any party other than defaulting state to invoke the breach as a ground for suspending the operation of the treaty. Okay, next, a material breach of the treaty for the purpose of this article consists in repudiation of the treaty not sanctioned by the convention. So we will understand that you have not signed the treaty at all. Violation of the provision essential to the accomplishment of the objective or the purpose of the treaty. So you are not following the provisions of the treaty, you are violating the provisions. Forging the paragraph or foregoing the paragraphs are without prejudicial to any provision in the treaty applicable in the event of the breach. So sometime what we'll say, okay, whole the treaty is applicable, but these 3 paragraphs are not applicable. So you may forego the paragraph and you can say balanced treaty is applicable. Article 61, supervising impossibility of performance. Now, supervening the impossibility of performance means sometime what happens, India, China, war is declared. Please understand, war or the stress is declared between 2 nations. India, Pakistan, another example. So whenever there is a lot of stress between 2 nations, okay, they may say it is impossible to perform the DTAA obligation because we are not in a good terms now. Okay, when we signed the agreement, we were having a good terms, but right now there is an impossibility. We cannot, there is no possibility to perform the duties which are mentioned under DTAA. So that also is there. A party may invoke the impossibility of the performance provision of a treaty as a ground for terminating or withdrawing from it if the impossibility results from the permanent disappearance or the destruction of the object dispensable for the execution of the treaty. You think that no, it's not 1 month. So we are discussing the article of impossibility. If the impossibility is temporary, it may be invoked only as a ground for suspending its operation. Please understand, if the event is temporary, if dispute between two countries is just temporary, 1 month dispute, 2 month dispute, then you don't have to terminate the agreement that has been signed by, a detailed discussion which has happened between two nations. So you can suspend for a couple of months, maybe 1 year, maybe 2 years. So that depends on, again, mutual agreements. So one thing is very, very important, and you should understand this. Impossibility of performance may not be invoked by a party as a ground for terminating or withdrawing or the suspending the operation of the treaty if this is very, very important line, if the impossibility is the result of breach of by that party either an obligation under the treaty or any other international obligation owed to any party. A defaulting party is, after defaulting, is saying this is the ground for breach of the clause. We are going to breach the DTAA, the treaty between the two nations, because we are not able to satisfy the obligation. If you are unable to satisfy the obligation, what is the obligation? When India signs treaty with any foreign country, say for example Canada, and according to treaty, a particular income derived by Canadian resident in India should not be taxed in India. Now, at the time of signing the treaty, they have signed the treaty, but later on they are saying, no, this is very impossible obligation for us. We are not able to follow this kind of obligation which was placed upon us by the treaty. Now, that cannot be basis. You understand? A defaulter cannot go and say, I have defaulted and this is a ground for withdrawing the treaty. Fundamental change in the circumstances. COVID-19 is the best example for fundamental changes in circumstances. Many international dealings, many international agreements, many organizations internationally have faced the consequence of COVID lockdowns. Yeah. So what happens in this lockdown period, or what happens in this COVID period, or where the trade is not possible at international level? So we will suspend the treaty. We will not terminate it. Definitely the first choice is suspension, and if it is kind of permanent in nature, then we will check for the withdrawing the treaty. A fundamental change in circumstances which has occurred with the regard those existing at a time of conclusion the treaty. So on the date of conclusion of the treaty, this event was not there. This event has happened after the signing the treaty, and at the time of signing the treaty, they did not estimate that something like this will happen in the future. It is completely unpredictable and completely beyond our normal human understanding, and we don't know, nobody knows what will happen after 3 months, after 4 months, and after a year. Okay, so fundamental changes of circumstances which has occurred with regard to those existing at the time of conclusion of a treaty, and which was not foreseen by the parties. They did not estimate for this, may not be invoked as a ground for terminating or withdrawing the treaty. So look at the negative language. So change in circumstances may not be ground. It may be, but it may not be the ground for withdrawing or terminating the treaty unless you should not withdraw, but still you can withdraw in these two circumstances. The existence of those circumstances constituted an essential basis for consent of the parties to be bound by the treaty. The basic fundamentals have changed. Okay, and definitely then contract cannot be, or the agreement cannot be performed, and the effect of change is radically to transform the extent of the obligation still to be performed under the treaty. So if one party is putting huge obligation on another party, it is a radical change. It's not 1%, 2% change. It's 100%, it's 90%, it's 80% changes of the circumstances. Obviously, they can withdraw the treaty by taking the base of change in circumstances. A fundamental change of circumstances may not be invoked as a ground for terminating or withdrawing from a treaty if the treaty established boundary, or if the fundamental changes is the result of breach by one party. Obviously, one party is breaking the treaty and then it's saying it is a fundamental change, either as the obligation of a treaty or any other international obligation owed to any other party. If under the foregoing paragraphs, a party may invoke fundamental changes as a circumstances as a ground for terminating or withdrawing from a treaty, it may also invoke the changes as a ground for suspending the operation. Okay, so obviously the first choice you should give for suspension, and then the second choice you should take it for the withdrawal. Okay, emergence of new Parliamentary norms of a general international law. Parliamentary norms means permanent norms. Something new has come, okay, which was again not covered by the agreement. Something new has come, definitely, and that something new is not temporary in nature, it is permanent in nature. So what will you do? If new parliamentary norms of a general international law emerges, any existing treaty which is in conflict with that norm becomes void and stands terminated. If something has changed permanently, obviously your treaty will not hold good. You have to sign a new treaty according to the new permanent norms. Thank you.